Good evening. I'm Jim Zirin, and you are watching The Digital Age. Tonight's show is about the extent to which international law may protect human rights on the internet. Human rights on the internet? Rights of free expression, rights of access to information. Tonight's guest is an expert in the field. She is a professor at New York Law School. Her name is Molly Land. We're delighted to have her with us, and she's just written a brilliant paper on an international law for the internet. Molly, welcome.
Thank you very much.
Now, tell me, what rules govern what's on the internet? I always thought it was local law.
It is, but there's a framework created by human rights law, among others, that set minimum standards for states to comply with in terms of the local law that they create for each jurisdiction. So it's human rights law is really a set of minimum standards, which is in some ways why they're drafted so generally, so that they can be applied across a wide variety of contexts.
Local law may forbid gambling, for example, on the internet. Local law may regulate pornography on the internet, although it doesn't seem to. Local law might read on a variety of digital conduct. Now, is there an international law that might trump the local law and prevent the individual states from exercising their right to regulate the internet?
Not at all. There's considerable freedom built into the regulations, the guidelines encompassed in the International Covenant on Civil and Political Rights, which is the treaty that I have been focusing on in my most recent work. Article 19 and Article 20 of that treaty, the ICCPR, really set out a general framework and create in some ways a balancing structure for states to pay attention to in terms of the local law that they create. And there's significant room within those provisions that allow states to protect local values, such as prohibiting gambling, while yet complying with the minimum standards that international law imposes. So, for example, Article 19 creates a baseline, protects freedom of opinion, freedom of expression, and freedom of information. If states want to limit, for a variety of reasons, it could be national security, it could be public policy, if states want to limit those expressive rights, specifically information and expression, they can do so, but they have to comply with a balancing test.
A balancing test. Now, what's a balancing test?
So the Special Rapporteur on Freedom of Expression, Frank LaRue, has talked about this in his most recent reports. The treaty requires the states to comply with principles of legality, legitimacy, and proportionality. I'm paraphrasing a bit. It's a three-part test. The legality phrase, prong of the test, requires states to do things according to the law, right? Not to act arbitrarily, but to establish principles in law and follow those principles. Legitimacy requires that the state regulate expression for legitimate purposes. So gambling might be a legitimate purpose. Certainly crime, regulating pornography, national security in some instances. And then the third prong says that whatever they do has to be proportional. And I actually think that this third prong is the most powerful part of the international law governing the internet, because it says you can only act insofar as is necessary to achieve that goal. So we couldn't, for example, ban all conversations about subject X just because we're worried that some of those might harm minors or have security implications.
Now, let's just back up for a moment. This treaty you talk about was adopted by the UN General Assembly in 1966. Isn't that right? Mm-hmm. There was no internet then.
There certainly was not.
Now, you argue that this treaty applies to something that didn't even exist when it was enacted. I mean, how do you find that? How do you figure it?
So the treaty, as you said, it was adopted by the General Assembly, and then it entered into force even later, actually. It didn't enter into force until 1976.
Still no internet.
Still no internet. I wanted to look at this article, if I could back up just a little bit, because there was a lot of discussion about the internet. There came to be a lot of discussion in connection with one of the special rapporteur's reports about whether there was a human right to the internet or whether there should be a human right to the internet. And I wanted to look and see what international law already may say about the internet. And specifically in Article 19 of the ICCPR, it mentions a right to a media of one's choice. And I wanted to know what that meant, because again, it might have a very different meaning at the time of the drafting than it does today.
So that might have been television or radio. You argue it is the internet, and it may be the medium of the future that no one's even dreamed of, isn't that right?
Precisely. And what I found in the drafting history was that kind of a flexible application is exactly what the drafters intended. They knew technology was changing rapidly. At the time of the drafting, which was in the late 1940s and the early 1950s, we were witnessing a technological revolution, right? So radio, television, all of these were becoming more important. Newspapers were not the only medium. And the drafters knew that things were going to change quickly, and what they had to protect was the medium of expression and not the particular technology. So it was very important that they adopted a technologically neutral approach to this problem. They knew that the means of expression was important, but they didn't want to lock in any particular technology into the treaty itself. So it is an evolutionary approach.
All right, so things have evolved, and I would have been unaware in the 70s that the reader of a newspaper had a human right to read the newspaper. I suppose the newspaper had a human right to express itself because it's a basic freedom of expression. But where in the internet do you find these values? First place, I have to have internet access before I can begin. Is there a human right to have access to the internet?
So looking at the drafting history,
to log on?
I argue that what Article 19 does by protecting a right to choose your media of expression is that it does provide a basis for claiming access to the technology necessary for that expression and to information online. So it's rights both respect to technology and content. Now, this doesn't mean that in any individual case I have a right to Facebook, for example. It does mean, I think, that when a particular communication channel is really the only way for me to express myself, and it has become so important to connection, as I think we can say of the internet. And here I'm thinking of, Secretary of State Clinton's statement about the freedom to connect, that this is really what things are about going forward. When a technology assumes that importance, I think you can make a claim to it. Now, again, the treaty doesn't say which technology, so it's going to depend on context. In some situations, it may be mobile phones, right, that provide the ability to connect to the world. There are no internet cables, and so it's mobile phones that provide that outlet. So it varies, but I think that if it's the only way for you to connect and to express yourself, then I think you do have a claim to the technology.
So that would be true of Facebook and Twitter. I mean, look at the so-called Arab Spring that we just witnessed, the Twitter revolution. Certainly the social media were used to mobilize dissent and mobilize expression of political freedoms of various kinds. So would you argue that these dissidents in the streets of Cairo or in Tunisia had a human right of access to Facebook and Twitter?
So it's a gray area. I can't give you an answer one way or the other.
I mean, it's dangerous to find new human rights everywhere you look, isn't it?
There is certainly a concern about rights proliferation. And those who have written about it, I think, have voiced very valid concerns that proclaiming new rights everywhere lessens the value and the rhetorical impact of the rights that we have. Now, I think that the work I'm focusing on here is looking to find these rights in existing law and not developing new ones, right? So I think that mitigates the concern a little bit. As with respect to Twitter and Facebook, the problem with Twitter and Facebook is that they're private parties, and historically, human rights law only binds governments. International law only binds governments. So there's an even more fundamental problem about making a claim to access Twitter or Facebook, is that it's a private service, right? Part of what I was looking for in the drafting history of the treaty was the extent to which the article might actually bind not just governments, but place an obligation on technology companies themselves.
Non-state actors.
Non-state actors to make these.
So you look at our First Amendment, our bulwark of freedom. That is doesn't read on private companies. It's a restraint on the powers of Congress. It's among a number of rights that the people have to be let alone by the government. So it says Congress shall make no law abridging speech or freedom of the press. Now you have the internet, and you're saying that international law might restrain Google from doing something?
In some circumstances. So I'll give a very, very qualified yes in the following way. And this seems very strange from a U.S. perspective with our understanding of the First Amendment, certainly. But the drafters of the treaty were clear. There was a proposal to make it limited to governmental interference with expression and information, and they explicitly took it out because they wanted the article to apply to private conduct.
Chinese hackers.
but not all private conduct. I don't think that it's I don't think that's possible to simply equate private and public conduct, because public conduct has a much more significant effect on our lives. So, what I argue in the paper is that in some circumstances, private conduct rises to the level at which it should be regulated like public conduct, and that is what is reflected in the drafting history. They were worried about situations where non-state actors occupied such a dominant space in the communications environment that they effectively controlled and could interfere with speech. In those instances, again, not that the non-state actors should not be able to act, but just that they would have to provide some explanation, the same way that the government would have to provide explanation if it decides to limit gambling or pornography or whatever limits it decides to place on speech.
Well, all right. So now Molly Land has gotten me connected. I've logged into Facebook. I've logged into Twitter. I'm in touch with people potentially all over the world. Now, does Article 19 also read on what I might say in those communications?
In what sense? In the
sense that if I'm expressing a political idea, down with Obama, and the government doesn't like that, does international law prevent the government from interfering, I mean, apart from U.S. law, but from interfering with the expression of that idea?
It certainly does say that speech is protected, and it can only be limited under certain circumstances. So the government would have to have a fairly compelling case as to why the statement "down with Obama" or whatever political speech it might be should be limited in those particular instances. So they'd have to justify it. But I would go even further and say it doesn't just protect political speech. Certainly that's the core of expressive activity, and I think internationally as well as in our domestic law. It protects all speech, all information and ideas of all kinds. And the drafters were very emphatic about ensuring that the protection was as broad as possible.
So how about hate speech?
So that is a special case under international law.
A special case.
It is, because they were very, and again, this was drafted in the post-World War II environment. They were also very concerned about the potential harmful effects of speech. And Article 20, which is, I think, the flip side of the coin of Article 19, not only allows, but in fact requires governments to prohibit what we would call hate speech. The formulation is sort of complex. It's speech that incites racial discrimination or hatred, but it's essentially what we would think of, I think, as hate speech in most contexts. That kind of speech has to be prohibited. Now,
Now, of course, in the United States, that kind of speech is not prohibited. It's protected by the First Amendment.
Yes.
So how do you deal with that conflict of laws? In Canada, hate speech is illegal. In England, it's illegal.
Yes, it's what Article 20 does is much more, it resonates much more with European and Canadian contexts in their regulation of expression. With respect to the U.S.'s, so the U.S. is a party to the ICCPR. With respect to its conformity, right, with that provision, certainly there are protections against hate speech in the U.S., which the U.S. could say comply with that. But the broader point would be that the treaty, there were certain reservations that the U.S. entered when it ratified the treaty that protect domestic exceptions, such as our regulation of expression.
Let's move on to another human right. I mean, there's a human right of privacy, isn't there?
Yes.
All right. So now I go on the internet and I denounce the government, and pretty soon the government, which is quite repressive, not the United States government, but some other government, wants to follow my buying habits, my associations, what books I buy on Amazon, and what books I consider buying but don't, and other services I might subscribe to. Does Article 19 prevent governments from that kind of intrusion on the privacy of an individual online?
So there are also independent privacy protections in the ICCPR, which would certainly have a bearing on that and may even prevent that kind of activity. I don't look at those provisions in particular. What I did look at is that at the time of the drafting of this particular provision, they sought to prohibit anonymity. It was a Brazilian amendment. Brazil in its domestic law also prohibits anonymity.
Well, now we're on anonymity. So, as opposed to privacy. Now, an anonymity is that I think I'm going online and I say down with Obama, and I don't think anyone knows who I am, but they do. At the time of the American Revolution, Tom Paine said, these are the times that try men's souls, and it was an anonymous pamphlet. Sort of anonymous pamphleteering is in the bedrock of American history. But on the internet, can we spy on people that make statements the government doesn't like?
I think that, I mean, and tracking is there's both public and private tracking, right? There's both tracking by the government and by companies that want to sell me things. That kind of tracking, I think.
That's called cookies.
Yes. So Article 19 doesn't speak directly to that issue. There was this proposal to eliminate anonymity, and what I argue is that the drafters just tried to not take a position on anonymity, thinking that it was going to work itself out in the balance between expression and lack of expression. I do
It's that famous New Yorker cartoon
Yes.
that you cite in your piece. It's on the internet, no one knows you're a dog.
Yes.
But they do know.
They do, and that's why anonymity online is, the internet is both the greatest protector and the greatest threat to anonymity online. And not just the internet, but all technologies. If you take cell phones, for example, we can easily locate people's geographic position by cell phones. So,
well, they have to agree to program that into the cell phone so that you could track it. I mean, that's an option for the subscriber as to whether he wants the tracking or not. Isn't that right?
There, to some extent, that's true with respect to, I think with respect to platforms, although I'm not sure precisely. What I was thinking about is the way in which cell phones log on to the internet. They typically use a fixed IP address or a fixed number, so every device on the internet has its own individual number, and
That's
cell
right.
phones use a fixed number that's easier to track than other devices. Now that again may change with the new IP addressing system that we have coming in, but it is easier, aside from the user preferences that you establish, it's easier to track geographic locations with cell phones. So I think Article 19 does not take a stand on anonymity, but the ease with which we can track people today requires us to reconsider the balance that that represented. and maybe we do need to have more explicit protections for anonymity in human rights law.
Well, it's sort of a virtual anonymity. I mean, I had a guest on the program, Emily Gould, who was into revealing all on the internet. And she called herself Divulgy, and she said that if you don't want to reveal private details about your life, practice internet abstinence and don't put them on. And so much of what we're sharing with others that maybe on second thought we don't want to share are things that we ourselves divulge online.
So I think that's generally right. I generally agree with that, although I would say that there are two special cases where the internet poses a real problem in terms of anonymity. The first is with respect to youth, right? Youthful indiscretion. Anupam Chandra at UC Davis has a great article called Youthful Indiscretion, making an argument for the ability to forget in some instances things that you put online.
That's a human right? My ability to delete some photograph that was taken when I was in college of a youthful indiscretion?
I would argue that human rights would support individual control and autonomy with respect to their information online. And to the extent that there are instances where we feel somebody didn't exercise, wasn't able to exercise a judgment necessary to determine whether or not something should be shared, there may be a basis for at least having that option available in domestic law. The other place where anonymity presents a real troubling problem on the internet is with respect to when it shields people who make hateful, degrading, defamatory statements. And it's a significant concern. And the next project that I'm going to be working on will focus on more on the hate speech part of the human rights framework, which will look at Article 20.
Or even false information. I mean,
Yeah.
suppose I say a certain building is on fire and has to be evacuated immediately, and it's totally false. Mm-hmm. It could be very destructive type of speech.
Well, that happened with respect to Hurricane Sandy.
Yes.
The Twitter feeds that were coming out, often they contained a kernel of truth, but then they, through the game of telephone that is our communications environment, became false stories over time and got propagated in the wind tunnel that is Twitter. Now, there's a couple of interesting things about that. First, Twitter was pretty quickly self-correcting, and people came up with contradictions to the reports that they were hearing. So in some ways, the fact that we have so many sources of information helps address some of the accuracy concerns. But certainly, it's certainly a concern.
Now, in your article, you stress the importance of software code. You say code is law, and that somehow or other we have to embed in our code on the internet a prescription for guaranteeing human rights, or at least some human rights. I mean, how does that play out?
So I can't take credit for the code as law. That's Larry Lessig, who
but you adopted it.
I adopted it for the international context.
You never have to be embarrassed about quoting Larry Lessig.
Exactly. So what I wanted to do with this article was simply call attention to the way in which many of the decisions that are made about technology have consequences for human rights, even if we don't see those decisions themselves as human rights issues. So, for example, the decision to switch to a new internet addressing system could have significant privacy concerns. And I think human rights advocates need to be at the table talking about those technological decisions to guard against potential harms to human rights. So I think that the idea of code as law, first and foremost, orients our attention in a way that I think is really important today. It orients us on the decisions that are made, the values that are embedded in our code. I think more broadly, and this is a project I'm currently working on, it provides a really interesting opportunity potentially for even enforcing international law, right? So code, the way it's set up, can either make it easier or more difficult for states to spy on people, to track their activities, to censor their speech. And again, there are values embedded in code. I would think it would be human rights consistent to try to pick the option that makes it harder for states to violate human rights.
Well, but the states have to be at the table too. I mean, perhaps the Ayatollah won't like that in his code. In fact, countries like Iran are going to have a national intranet and won't be part of the World Wide Web. Is that to get out from under the application of international law?
No, the international law wouldn't depend on. It just applies if a state has ratified the treaty. It's ratified the treaty, and if it doesn't comply, it doesn't comply. But I think that states are increasingly trying to control the information space by things like gateway filtering, through economic policies that really encourage and foster domestic content that the government can control. And I think that is problematic from a human rights perspective and from the perspective of Article 19, which explicitly says we guarantee the ability to express yourself across frontiers.
Now, your conclusion, really what you're trying to get at is that human rights law must not be undermined by technology, isn't that right?
I think that's
Isn't
fair.
that what you're trying to say? And so I have a question for you, Molly Land.
Okay.
Is there an international law of the internet that protects human rights?
Yes.
You think there is?
I do.
Molly Land, thank you so much for coming by.
Thank you
This has
very
been
much.
marvelous, really
It's been
fantastic.
delightful.
And I commend you on your article, and I wish you luck with it. And thank you for coming by. Tune in next week for more on the digital age. Don't forget to visit our website at www.digitalage.org. For the Digital Age, I'm Jim Zirin. Good night and all the best.